This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about the use of an independent medical examiner when dealing with a third-party liability claim to help determine the value of that claim. So when a claimant claims an injury that does not seem to agree with the facts of the incident claimed to have caused the injury, the adjuster or defense counsel will often seek the assistance of an independent medical examiner, an IME, to verify the extent of the claimed injury. The IME is usually a forensic physician or a chiropractor who has agreed to evaluate an injured person for a fee and is not involved in the treatment of the injured person. In Pennsylvania, for example, an insurer providing medical benefits to its insureds following an automobile accident did not have to establish good cause before the insureds were required to take physical examination administered by a doctor of the insurer's choice, even though a statute provided generally that the insurer seeking to compel independent medical exams was required to show good cause. The policy gave the insurer the right to order the examination without establishing good cause, and this was held in a case called Fleming versus CNA, a 1991 decision of the Pennsylvania Superior Court. Independent medical examinations are within the trial court's discretion and are not available as a matter of right unless there is a contractual requirement. Therefore, before a trial court orders a party to submit to an independent medical examination, the party requesting the examination must show good cause. Where a claimant requested an independent medical examination because of disputes regarding whether she had reached maximum medical improvement and whether she had any permanent impairment, it was equally apparent that no dispute existed regarding the medical care that had been provided by a managed care plan, because the claimant was not seeking the independent medical examination to resolve a dispute regarding the medical care that had been provided by the managed care plan. The provisions of state statutes were found to be inapplicable. The claimant's entitlement to an independent medical examination was controlled by Florida statutes, and pursuant to that statute, she was entitled to the independent medical examination requested. This was an effort to get more benefits from an insurance policy rather than an effort to reduce the value of a case by a third-party liability insurer. It is imperative, however, when a third-party liability insurer suspects fraud, to always use the IME in good faith. SIU investigators, who by definition see mostly people who are attempting to defraud an insurer, will often be involved in retaining the services of an IME. They and the physicians they employ as IMEs will occasionally lose sight of the insurer's obligation to treat its insured or a claimant fairly and in good faith. The SIU or adjuster must always instruct the IME to provide only his or her professional opinion based on review of records and physical examination of the claimant or the plaintiff. The insurer should never suggest a finding to the IME. Doing so can be and will almost always be construed as an act of tortious bad faith. One such misstep was reported in a case called Sprague versus Equifax, a 1985 decision of the California Court of Appeal, where the court found, among other things, that the investigator wrote to Dr. Ramey, the IME, regarding the plaintiff's examination and said, quote, "I am representing Top Inc. They have asked that I have you examine one of their insureds who is currently on disability. Mr. Sprague has been disabled since May 31, 1975, due to a back problem. We do not know the exact nature of his problem. In your examination, please determine whether or not you would consider him to be totally and permanently disabled from any and all occupations for which he might reasonably be fitted." In fact, Tom had not told Mr. Roth, the investigator, that they did not know the nature of plaintiff's problem, and Mr. Roth did not request more information. Mr. Roth also did not inquire what definition of disability applied to the plaintiff under the insurance policy, and did not inform Dr. Ramey that under California law, plaintiff would still be deemed disabled unless he could perform the substantial and material acts necessary to a business or occupation in the usual or customary way, or that he would still be disabled even if he could perform sporadic tasks. Dr. Ramey's report, dated May 6, 1977, the same day as the examination, concluded that plaintiff was suffering from a lumbosacral strain and degenerative arthritis and should be restricted to light work with a minimum of physical effort. On May 12, Top cut off benefits as of May 7, based on the report. Mr. Namel, the adjuster, testified that he was told by his supervisor at Top that the purpose of a claims department was not to find ways to pay claims, but to find ways to deny claims. Thus, based on Dr. Ramey's report, he felt that there was sufficient information to deny plaintiff's claim, and that it was unnecessary to consider any other information. The truth was the opposite of what the insurer testified to. The purpose of a claims department is to find ways to pay, not to deny claims. The purpose of the claims department is to keep the promises made by the insurance company's policy. The $5 million verdict that resulted in the Sprague case made insurers much more careful when they ordered independent medical exams in California, and hopefully will never again tell an IME what to conclude after doing the examination. Much time has passed, and insurers are forgetting the lessons taught in Sprague. The errors made by the investigators and claims people were breaches of their ethical obligations. They should have instructed the IME as to the proper definition of total disability, and should have known that the disability benefits were owed when the IME reported the existence of degenerative arthritis. It is the obligation of the adjuster to obtain the best and most accurate information available from the medical examiner. The adjuster should be ready and willing to advise the insurer to pay benefits if the IME establishes that the person being examined was truly injured, or be ready to revise the evaluation of the case based upon the IME's advice. The party moving for an IME must demonstrate to a court the following: 1. That the physical or mental condition of the party sought to be examined is in controversy, and 2. That good cause exists for requiring the party to submit to an examination. The absolute privilege protects the IME doctor from potential liability for allegedly defamatory statements made in his IME report, but it does not protect the insurer. In 2003, in a case called Chapman v. Mayo, Justice Hickman of the Supreme Court of New York, the trial court, expressed serious displeasure with an insurer's conduct. In an action to recover damages for personal injuries, the defendant's unsuccessful attempt to result a jury verdict of over $1 million for the plaintiff's injuries was made on grounds that raised the ire of the justice. After complaining about the defendant's and his insurer's lack of cooperation in the settlement process, Justice Hickman found it necessary to comment on the IME presented by the defense. The judge, without an obligation to do so, opined, quote, "In defendant's expert physician's file, which plaintiff's counsel was allowed to examine prior to cross-examination, was a request that the doctor conduct an IME. Attached as an exhibit to this decision is a copy of this request marked at the trial as Plaintiff's Exhibit 14. The contents of this request raise serious questions about whether the courts are being seriously and routinely misled by the concept of a truly independent medical examination. If, in fact, as seems clearly to be the case here, many doctors who perform IMEs are being directed to only make findings adverse to a plaintiff and do not advise of anything favorable to that plaintiff, there is no independence. Independence doesn't exist at all. It is clear that in many legitimate lawsuits involving serious injury, the insurer is intentionally suppressing medical information that should be a part of the file. How can those responsible for evaluating and settling cases do so fairly, effectively, and justly when they do not receive critical information from an IME? The whole purpose of an IME is to give the carrier an opportunity to do their own medical evaluation. It should not be used to suppress all information favorable to a legitimate plaintiff with serious injuries." Close quote. Although the insurer was not a party to the action, Justice Hickman wanted it made clear to the defendant insured that he was treated wrongfully by the insurer. The judge was so angered, and properly so, by the wrongful conduct of the insurer that he solicited the insured defendant to file a bad faith suit. To avoid charges of bad faith, every insurer and its personnel should apply the golden rule and treat every insured and claimant as they would expect to be treated by their own insurer. Every assignment to an IME should be non-committal. Please, it should say, examine the patient and tell us what you found in your professional capacity. It should never tell the physician what to find. This video was adapted from my book, Zalma on Insurance Claims, Part 107, Second Edition, which is available from Amazon.com as both a Kindle book and a paperback. Please, if you found this video to be useful or of interest to you or your colleagues, refer it to your colleagues. It's free. And please also subscribe to my Rumble channel, my YouTube channel, and my blog so that you can be advised of future blog postings and future videos. Thank you for your attention.